All right,
Give
thank
this to
you.
probation or the clerk?
Oh, just give it to probation.
Yeah.
All right, are you all ready on Mackie? All right, we're back on the record in 2014 CR 2014 CR 5495, State versus Joshua Mackey. If I could have parties re-announced, please.
Defendant for the state of Texas. And Kelly Piddle for Joshua Mackey.
All right, and this is a continuation of the hearing that was started this morning. State, any witnesses?
Fortunately, it's not having partners.
All right, defense, any witnesses?
Defense rest, Judge.
All right, the court has found violation of condition number 5 true. The court is going to find violation of condition number 1 not true. The court is going to find 15 FF not true. All right, any objection to the court reviewing the court summary?
None from the state. Can I see it?
And for the record, the court has not reviewed the court summary.
Can I remove the violation reports?
You'll have to speak with probation about it because that's their court summary.
I just don't, I have no problem with you speaking to the court summary, but not the violation reports since they're not. Okay, that's right. No objection, Judge.
Oh,
so
you have your own? Sorry.
No, I don't.
oh, okay. Then, yeah, that's just.
All right, so what portion are you all asking me not to read?
Yeah, I didn't realize that the violation reports are already in the court's file that you
Yes.
that's taken judicial notice of. So no objection, Judge.
Okay.
And if we could just have time for a brief argument after.
Yes. Oh, and counsel, I don't have a trial court certification.
We'll get you one, Judge.
Okay. Oh, do you want to grab that while I read this?
Sure.
We open mid-hearing, and already the courtroom energy is tense. The judge is sorting through probation violations like a puzzle, some true, some not. This moment sets the tone. Facts over feelings. Watch how methodical she stays, even when things get emotional later on.
And state defense and Mr. Mackey, I see that there's a condition of number 1 in here. I previously said that that condition is not true.
Yes, Your Honor.
So I'm not going to consider that because I found it not true. And it's the same dimension of condition 15 FF. I've also found that not true.
Thank you, Judge.
Okay.
Judge, can I present to support?
Yes.
I'll have it marked if you would, David, too. The state has waived this condition 10D, but I just wanted to bring it to the court's attention that the restitution is paid in full.
So was the restitution 36,000 or was it 44,775?
It was, what he owed was the 4,000 number.
Okay.
The total was the 36. The 4,000 was paid.
All right, the court has reviewed the court summary and the court has reviewed the document that the defense asked the court to review. State, what are you requesting?
Your Honor, you've taken judicial notice of the entire court file. You're aware of the facts of this case, the egregious nature of them, involving shooting the victim through the head, the right temple, exiting out the left side of her face. Very well could have killed her. Thank God it didn't. Otherwise, we'd be here on a different charge. So given the facts of the case, given that the defendant is on his second MTR since he had been placed on probation, and given the one true violation you found, Your Honor, state would ask for him to be revoked, adjudicated guilty, and sentenced to 10 years TDC.
All right, just one moment. I'm just trying to find in the court's file, I'm trying to find the admonishments page.
Give us-
Were you all able to see that? The admonishments page?
I don't recall, Judge.
If you could. And everyone, just one moment.
This is a key procedural insight. The defense is pushing back on what evidence the court can review. They're basically saying, Judge, don't look at that. It's not officially part of the record. It's a classic tug-of-war between fairness and thoroughness. The judge's response? Calm, but firm. She's seen this dance before.
All right. So as a part of your plea bargaining agreement that was entered into, the state was silent on your application. So I'll note that for the record.
Yes, Judge.
All right. Defense, the state is asking for revocation. They're asking that your client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court, we believe, should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And I don't.
The admonishment from the secretary, which I can find it in this file.
Oh, the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous.
Are you looking for the plea bargain number?
I have the plea bargain, but there are no mention of no contact or, I'm sorry, there are no mentions of any no contact orders. So
I have,
I'm sorry, Counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain to him.
want to see.
Yes, please. Okay. All right, there should be no contact. There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison, give you credit for any time served. Is there anything else?
We asked for findings in fact and conclusions of law.
Understood.
And have you gone over the trial court certification?
I have not, because
All right, if you'll
he
go,
needs time to understand it.
yes, okay. And then just come back and I'll